Hello, my name is Ghaz Iqbal. I'm a partner at Harrison Solicitors and I head up the road traffic department. You have a driving licence, and on that licence, if you receive convictions for endorsable offences, for example speeding or no insurance, your licence will normally be endorsed with penalty points. Over a 3-year period, if you obtain 12 or more points on your licence, you'll be liable for disqualification under the Totting provisions. You can have a maximum of 12 penalty points on your licence over a 3-year period before you face disqualification. This disqualification is mandatory. Although this is a mandatory disqualification, there are ways of avoiding a disqualification. Just because you have accumulated 12 points on your licence doesn't mean that you will automatically be disqualified. This is commonly known as arguing an exceptional hardship, namely that if you lost your licence, it would cause you, or more importantly, people around you, an exceptional hardship. To do this, you have to persuade a court, in particular magistrates, that by disqualifying you from driving for a minimum period of 6 months will cause you or others an exceptional hardship. For example, if you lost your licence, you would lose your job. The knock-on effect of that would be you'd lose your home, as you wouldn't be able to keep up with the payments, whether it's mortgage or rent, and it would have an impact on others. Penalty points stay on your licence for a period of 4 years. They are relevant for the sake of disqualification purposes for 3 years. You have a 3-year period where if you accumulate 12 or more points, you will be liable for disqualification under the Totting provisions. If you have reached 12 penalty points on your licence, then the likelihood would be that you receive a summons from the local magistrates court asking you to attend in order for the court to consider disqualifying you under the Totting provisions. The courts do, however, have the power to disqualify in someone's absence, so it's always important to be aware of any correspondence you receive from the courts. This disqualification is for a minimum period of 6 months. It can in fact be longer. I deal with all the cases from start to finish. This includes the first appointments, all the preparation, as well as the advocacy at court. I deal with these types of cases up and down the country and have been doing so for a number of years. The most important thing about these types of cases is the preparation and ensuring that I have all my clients' details and to ensure that they have the best possible chance of avoiding a disqualification under the Totting provisions. The majority of my clients don't live in the area where I practice. This does not cause any difficulties, as I conduct cases up and down the country, as far south as London and as far north as Newcastle. Delaying your case will not mean that you will avoid a disqualification under the Totting provisions. The reason behind this is that the court will look at the date of the offence as the relevant date to see how many points you had on your licence at that point. I offer a competitive fixed fee arrangement. This incorporates all of my attendances, preparation and the advocacy. My clients prefer this as they know exactly how much the cost will be from the outset of their case. These types of cases can take some time before they are resolved. For example, if you've committed a speeding offence, you will initially receive a notice of intended prosecution. This notice will come from the police. Once you respond to this notice, the police will then have to consider whether or not to offer you a conditional offer of a fixed penalty ticket. Once this is sent to you, and you say, for argument's sake, you return that fixed penalty ticket, the police will then realise at that particular point that you will not be eligible for a fixed penalty ticket as you have 9 points on your licence. This will then mean that the case will be referred to the local court that deals with the road traffic cases in your area, and then the court will contact you initially asking for your pleas. To give you the opportunity of arguing against disqualification, you will then receive a summons to attend court. Normally, when you accumulate 12 points on your licence, the magistrates will have to consider disqualification under the Totting provisions. However, there is a way of avoiding a mandatory disqualification and instead asking the magistrate to deal with you by way of a discretionary disqualification for the offence itself. This is normally not something that the magistrates will consider doing. The higher the speed, the more chance you have of arguing that you should receive a shorter disqualification for the offence. By arguing this, you're not advancing an exceptional hardship argument, and more importantly, you're not receiving the penalty points as you'll receive a shorter disqualification instead. One case I dealt with recently resulted in my client receiving a 28-day disqualification, despite the fact that he was caught speeding at 60 miles per hour in a 30 mile per hour zone.